much, Mr. Thanuvat. So, welcome to the afternoon sessions, ladies and gentlemen. Let us get back to the third sessions of the World Judicial Integrity Forums of 2026. I am Nhonlaphat Pitpiboonpreeya, Director of the Bachelor's of Laws program from Faculty of Law, Rangsit University. And once again, I will be your moderator for these afternoon sessions. And in our third sessions, we shall discuss the topic regarding commercial courts, insolvency reform, and investor confidence in Asia. And we are honored to have the experts from both Malaysia and Brunei as our panelists in these sessions. So ladies and gentlemen, please welcome our first panelist, Mr. Wan Kai Chee from Malaysia. He is co-head of the Financial Service Department and partner of Rahmat Lim and Partners, which also associate with Allan and Glenn Hill in Singapore. Our next panelist is Mr. Syahril bin Rahman from Malaysia. He is the Director of the Policy and Legal Division of Malaysian Department of Insolvency. And our last panelist for this session is Mr. Mohamad Daud bin Ismail from Brunei Darussalam. He is a lawyer, advocate, and solicitor of Daud Ismail Company and the adjunct lecturer at the Faculty of Law of Sultan Sharif Ali Islamic University. Ladies and gentlemen, in order to gain investor confidence and maintain economic stability across Asia, especially in interconnected economies nowadays, the commercial courts needs to play a pivotal role to strengthening commercial court specialization, improving insolvency procedure, especially effectively balancing the corporate recovery and creditor protections, and reducing procedural delays and improving consistency of the adjudications. The court also need to enhance the cross-border recognition of the judgment, and these are the scope of the focus that we are going to discuss in this panel discussion. So without further ado, ladies and gentlemen, I would like to invite Mr. Wan Kai Chee to present his opening remarks.
Hello. Hello. Hi. I'm Kai Chee from Rahmat Lim, and we're a law firm in Malaysia, Kuala Lumpur, and we're part of Allan & Gledhill, as mentioned just now. So Allan & Gledhill, we've got offices in Singapore, Vietnam, China, Indonesia. So we have different regional offices, and our focus is well, we have full service practice, meaning corporate work and litigation work as well. And litigation including restructuring, restructuring all the way to insolvency. And one of the main practice areas we have and that we help clients with is investment, right? Investment, foreign investment, cross-border investment. And so of course, this thing is very important when we look at the contracts, investment contracts, M&A agreements. It always comes up, right? Firstly, the clients will look at the country, see whether whether it's suitable for investment or not. So a lot of macro considerations, the business case and investment case. So that always comes first. That always comes first, basically whether they're going to make money or not, based on taxes, incentives, things like that. But also a very important thing, and I think it's been discussed a lot this morning, the rule of law, right? That what you can expect, whether or not, when you sign contracts, when you put in your money, the money is safe, right? So that's, of course, very important, and a lot of times we're talking about millions and billions. So for any country to be able to make sure that investors will come in, that the capital can be attracted, all the correct things need to be in place, and this includes things like investment treaties, right? So G to G arrangements to make sure that if there is some problem, there could be maybe even investor-state arbitration or claims available for the foreign investor. In terms of what we see, daily, that is a practical aspect of this topic is the dispute resolution clause, right? So, of course, we're talking about judiciary now and the courts, and there is the alternative today adopted by many jurisdictions of arbitration. So, just looking back, arbitration is a very old thing already, and it's well established, but the reason why it came about is because, maybe a lot of parties felt courts were not working as well as they should be working, meaning, the kind of disadvantages you might have found in the past, maybe nowadays you don't really see those problems, or the problems are different, or maybe the problems are reversed. So often, actually, we choose arbitration, or we talk to clients and say, okay, choose arbitration instead of court. But yes, there are still cases we advise clients use a court dispute resolution. Previously, it used to be things like cost and delay that mean that you want to stay away from court, that you want to go to arbitration. But today that can be reversed. So arbitration can take longer, and the costs can be higher. And in terms of enforcement, arbitration, as I mentioned, there's more and more now being done where it's more easily enforceable, more directly enforceable, and no appeal. So that's pros and cons. There are pros and cons to it. Arbitration, you have a case where it's private, and you don't really go into the situation where there's precedent, right? So there are also benefits. There could be benefits there for certain parties where if you have a dispute and you settle it in a certain way, whether there is a precedent against you for future cases, because in Malaysia being a common law country, that's relevant, whether that there is reported cases for the same point, because then that will be binding on you if you have disputes, similar disputes in the future. So also along the way that we will find that there are various other things relevant for investor protection, and that's, I'll just start with that. Thanks.
Thank you very much, Mr. Kai Chee. And now I would like to invite Mr. 𝗍𝗍𝗶𝘀𝗍𝗶 to deliver your remarks.
Hello, good afternoon, everyone. My name is Nick. I'm from the Department of Insolvency Malaysia, or better known as MDI. I realize that this is such a challenging time. I'm referring after lunch. So I try my best to keep things short. My opening remarks is anchored on my slides. I'll be talking about insolvency reform in Malaysia. What we have displayed on the screen is the map of Malaysia, consisting of two key areas, the Peninsular Malaysia as well as Sabah and Sarawak. Okay. Why insolvency reform matters? We want to show that insolvency is no longer a domestic matter. Just like other things, it has stretches across the globe, across jurisdiction, and through digitalization. I want to show the journey that Malaysia has shared. We have managed to evolve and pass through many reforms. We have embarked upon the transformation of personal insolvency as well as corporate insolvency. The traditional approach has been asset realization, creditor recovery, as well as formal winding up. But now the modern approach is rescuing businesses, make it more viable, and the going concern must be preserved. And we also do our best to protect the employment opportunities of people who are in the system. And we want to ensure that there's continuity in economic value. Our reform philosophy is this: saving viable enterprises creates greater justice rather than premature liquidation. The globalization of insolvency, we see that a typical Malaysian company may have creditors in Singapore, assets here in Thailand, financing in Hong Kong, arbitration in London, and digital assets, including cryptocurrency, globally. So without cross-border cooperation, proceedings may become fragmented and localized. The cost will multiply, the time taken will multiply, the value of the assets depreciated, and the judicial conflicts started to contradict and converge. The result would be an inefficient, uncertain, and injustice to the parties concerned. So this is our jewel in the crown, the Cross-Border Insolvency Act 2026. This is based on 𝗠cie trial, model law on cross-border insolvency. Our objectives, as listed there: international cooperation, judicial coordination, recognition of foreign insolvency proceedings, efficient restructuring of multinational enterprises, and this is what people want: greater certainty for investors and creditors. This is our journey. If you would notice throughout this roadmap, it highlights the 9-month period. This is something that the global community is praising Malaysia. This is our landmark achievement. We managed to pass this Cross-Border Insolvency Act within 9 months. Akin to say, I just want the baby without knowing the labor pains. These are the 17 key agencies that were involved from the ideation until the realization of the cross-border insolvency. And you would notice this cut across the board, not just a singular government entity. And the 4 pillars of ancestral model law framework, we have already gone through this discussion in New York last month. And why this reform is historic for Malaysia? There's a paradigm shift. Previously, we rely more on common law principles. Now it's more structured, more recognized regime, more harmonized procedures, and international cooperation framework with other jurisdictions, and increasing judicial certainty. The transition is from territorial insolvency towards cooperative global insolvency governance. The key driving theme of this forum is integrity. This can also be found in cross-border insolvency, where the judiciary as global coordinators can converge in a single proceeding. The recognition of other jurisdictions' decision, this is a game changer. The regional impact on ASEAN. ASEAN can be a hub for insolvency. This is something that we can unlock together. Everybody wins based on this win-win basis. That's the impact. And we hope to drive our neighboring countries to come on board together. Together we can make it with the ASEAN spirit. And everybody knows that the economic and the investment implications, there's a multiplier effect to this. The impact on financial institutions. Everybody likes this. And the impact on the Malaysian legal profession. This creates cross-border insolvency specialists. And like Datuk Nordin earlier in the morning mentioned, that there is a specific judicial academy that has been set up in Malaysia that will be the driving force for this. And the center of main interest. For those who followed the 𝗠cie trial discussions, they would know that there is already a growing interest in 𝗠cie. And we cannot run away from technology. Everybody's talking about it. Crypto assets, AI enterprises, digital platforms, cloud-based assets, and decentralized finance, DeFi. And that would mean asset contact tracing would be a challenge. We don't want to see another Jolo. The challenges ahead. We need the judges and judicial officers to increase their capacity building, as well as the enforcement. We need more bite than bark. And there is differences in legal traditions and customs, and also the cost of multinational proceedings. We have yet to see this because the Cross-Border Insolvency Act would be enforced in Malaysia next month. The central thesis for justice, reform and resilience, we combine that under the Cross-Border Insolvency Act. It's not just a legal reform, but a total transformation of the Malaysia's economic governance architecture. And this is our vision for Asia. We want to see an Asian insolvency cooperation framework using and leveraging ASEAN judicial insolvency protocols. We want to have a regional recognition arrangements. We want to have a shared judicial training, digital insolvency platforms, this can be done, as well as cross-border court communication mechanism. This will shape on how we want to move forward, a resilient, rules-based insolvency ecosystem for the Global South. The key takeaways from today's session, I would hope to see that the institutional maturity, commitment to the global standards, economic modernization, and the judicial evolution to carry out these tasks. Ultimately, the message is effective insolvency systems are essential pillars of justice, economic resilience, and global trust. In a connected world, justice cannot stop at national borders. Insolvency reform is therefore not merely economic policy. It is a commitment to fairness, resilience, and the rule of law. I believe this is the common values that we share here today. 𝗍𝗁𝗏𝗏. Thank you.
Thank you very much, Mr. Syahril. And now I would like to invite Mr. Mohamad Daud bin Ismail to deliver your opening remarks.
Thank you, Ms. Moderator. I'm happy to be here today just to share based on Brunei perspective. So it's a privilege for me to be here in Bangkok. Thank you for the organizing committee to basically to invite me to share Brunei perspective on how commercial court and insolvency reform help build investors' confidence across Asia. I think for a start, Brunei believe a strong institution. Independent courts are the bedrock of economic growth. When investors trust contracts will be upheld, and then of course insolvency process will be fair, predictable. So this forum is basically timely for us to exchange our ideas so that we are able to share the common goal to ensure that the investors' confidence will be upheld. Now, I've just start on commercial court in Brunei Darussalam. I think as you are fully aware, I think we are common law system, and basically the courts have deep rooted with the common law, and of course this system has been considered. In Brunei, I think we are still maintaining our basically with UK, and in fact we have our courts up to the Privy Council. It's something that is a bit rare, but I think it's only in civil cases, and also it will be it must be agreed upon during the High Court stage. But essentially, I think importantly, I think the commercial court in Brunei, I think will actually contribute to the confidence in investor. I think what we have, I think it was introduced in Brunei in February 2016. And I think this is important because this commercial court will deal with cases concerning basically the problems or disputes between the parties. And so we have this, what we are having is a speedy efficiency. I think it's important and of course, we have specialized expertise. We have judges who are possessing basically in areas such as banking, insurance, and construction, and international trade. Of course, we have also, I think, alternative dispute resolution that is available, arbitration. I think that's very valid, and that is also in practice. But we have our own Brunei Arbitration Center in Brunei. I think that has been important step for us to try to resolve, I think, the dispute between those investors. And in fact, I think the Brunei Research Center is leading mediation, arbitration, and other dispute resolution. Yeah? So, of course, as we have been talking about technology, I think our courts also basically have dealt with this e-judiciary case management, I think, to resolve basically the approach. So with the digital approach, I think we hope to be able to more accessible to local and international investors. Now, as we know, commercial court, basically, we have these issues of, I think Brunei is adopting Brunei Vision 2035. I think this is something that we are hoping to establish Brunei as a stable hub for investment and competitive landscape in Brunei. Yeah? Of course, as I said, the Brunei adoption of the arbitration is one of the areas that we are looking to promote this, promote the basically resolution of the dispute, not necessarily through the court system, but I think through arbitration and mediation. So that. Now, looking at insolvency reforms, I think this is an area that my learned friend from Malaysia has spoken very well, but we are also developing this particular area. So we, our insolvency reform is founded in an act, Insolvency Act 2016, very new, but we are looking at this one as to allow, I think that's what the issue of rescuing distressed companies from being winding up. I think this is an area that we are also looking into ensure that the problem company can be rescued and rehabilitated so that the company, problem company can be in. So the highlight of this basically of this insolvency reform, there are two areas I think that is important to look at judicial management. The company will look into a judicial manager to resolve the problem that is faced by the company is in trouble. And then there is also, we call it CVA, Corporate Voluntary Arrangement. So this allows the creditors to look into a possible rescue of the company, so to allow it to be. So we have this basically in these reforms, I think I just want to share, this is what we call it, the shift towards rescue and rehabilitation. I think it is important so that the company will not be winding up. But when we rescue the company, of course, in the end of the day, we are looking into the preserving the business and, of course, preserving the jobs and value of, and also the investors' confidence. Of course, importantly, the issue of having this insolvency reform is to ensure that the creditors are also being protected. I think we look into this, so the interests of the creditors will be protected. And of course, there are issues of receivership work. I think it's like I think was in Malaysia, I think they are now further with, we have this cross-border insolvency reforms, but we will be properly looking into the area as well. I think that's important to have a clearer framework for cross-border so that we can resolve it in a more structured manner so that we will be able to look into as well as that. Now, as just to conclude in respect of resolving this impact on foreign investment climate, I think what we have here, the synergy between our commercial court and response created basically a balanced legal system in Brunei. So we will be able to allow there was enforcement of contract between parties. Of course, there is this issue of trying to, if there is any problem, the early exit. And of course, there is a risk reduces mitigation area. Of course, the foreign investment in Brunei, we have foreign investment, and this reform will be able to allow that. Now, just to conclude this session, we will basically, the purpose of having proper commercial courts together with insolvency reform will be basically allow us to see a more better framework, and also that would allow the investment into between the cross-border investment can be improved. That would be sharing the perspective of Brunei system. Yeah, thank you.
Thank you very much, Mr. Daud. So, okay. Yeah. So now we are moving to the panel discussion. So firstly, I would like to ask Mr. Wan Kai Chee, as an expert of corporate and financial matters of both domestic and cross-border transaction, how can judicial system better support investor confidence through transparent and reliable dispute resolution mechanism?
Yeah, so in Malaysia, we've had many things happen, including, as my colleague mentioned, Jolo, you all maybe know him. But other things, very big restructurings, big insolvencies, listed companies delisting, having to delist. So yes, many problems, but of course a lot of these are not so related to the court, right? So the court does what they do, and a lot of the times it just everything has happened elsewhere, and it's just that there's one part. It's not even everything. Just one part goes to court, and then court needs to say something about it, right? So a lot of the time, it's for parties, it's the almost on the one hand, it's maybe supposed to be the first resort, but it's also often the last resort, where the regulatory framework, the government action or whatever else could have happened, didn't solve the problem, then you need to go to court to enforce your rights, right? So, and there have been some examples of how for parties, right, for companies, you can have practical issues coming up, right? And so one case I would mention is this case which we are working on, and it's still ongoing. It's actually in two parts. There was one litigation all the way up to federal court, and then the counterparty lost. Counterparty is a listed company, Malaysian listed company. And then they tried again. So the company board did a second action against our client. Our client is a foreign investor. So, and so that is still ongoing, and it's under appeal process to federal court. So as you may know, in Malaysia, federal court is the highest court, and it ends there. Before that, it's Court of Appeal and High Court generally. So the issue here, specific issue here, is that after the first litigation, right, there was an AGM of the listed company, and then the shareholders were talking about this thing where, you know, the listed company was suing our client, and then they asked, oh, so how much has it cost for us to go all the way to federal court and lose? So the director said 800,000 ringgit, which is about 6 million baht. So lawyers were paid 6 million baht for going to federal court and losing, right? So which is you know, which is what happens. But then the company started the second litigation, right? And so the issue here is that all the time when companies do that, they are spending the company's money. It's not the director's own money, it's the company's own money when they sue the shareholders, right? And so it's not to the loss of the board or the individual directors, because it's not their money, it's the company's money. And what happened for the second litigation is it went to High Court, and the High Court held in favor of the company, this company, to say, okay, directors, when you do this, when you make this claim, it's correct, right? And then it went to Court of Appeal and was reversed. So Court of Appeal looked at it and said, no, 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 this is definitely wrong, right? You were wrong to sue for this, and you know, impliedly, you were wrong to spend the money, because legal fees, you know, I'm a lawyer, but still, it needs to be correctly spent, right? So the issue here, though, is that because the High Court already held in favor of the listed issuer, it's going to be very hard to go against the directors to say, okay, you know, directors have directors' duties. Very hard to go back to them and say, hey, you're in breach of directors' duties, please pay. Please pay back the company, because, you know, the shareholders are the ones who are actually affected. So yes, even though with the court system there's appeal, and you know, it's not so simple that if you are a judge at a particular level to say, okay, I'm just going to decide this way, if it's wrong, somebody else will fix it. In this sort of case, there's an implication, which is, you know, we will be telling our client, no, you can't sue the directors, because if the High Court judge can think that is the correct thing to do, then, you know, you as a director, you're just a regular person, you know, you're not a lawyer, you're not a judge. If you think that's the correct thing to do, then it is, you know, very well justified. So so that was, you know, just one case I'll talk about that, and it's still a current one, and you know, there are other examples as well, but yeah, I'll just mention that one.
Yes, and how do you think we can solve that, in your perspective?
So I think, you know, us as lawyers, we also know judges, right, from our contact, whether from work or from university or as neighbors and friends. So there is like what I mentioned, a little bit of thinking where, you know, and sometimes to say, yes, I'll decide this way, and it's wrong, somebody else will fix it, you know, if you're not federal court. So that shouldn't, you know, you should try to move away from that thinking, because, you know, it can matter.
Okay, thank you very much, Mr. Wan Kai Chee. And now I would like to ask Mr. Nick Syahril, sorry, that in this kind of problem, you know, how can we reform to improve the efficiency and predictability of insolvency and restructuring framework across the region?
Okay, number one, you need to have the right law. Number two, you need to have the right people. Whether as a judge, as a lawyer, as a creditor, as a shareholder, as a director. Because court would always be the last resort. Essentially, what we have in insolvency is people are fighting over claims. People are in debt all the time. But once the court, because in the case of Malaysia, the jurisdiction for winding up is at High Court. We have 21 High Courts in Malaysia. Where there is a High Court, there is a Department of Insolvency. When it comes to winding up, we wear our hat as official receiver. We have liquidators who would scramble for companies that has valuable assets. At the moment, we have about 28,000 of winding up cases throughout the country. And out of that 28,000, 27,000 comes under the purview of official receiver, where we act as provisional liquidator. That means these 27,000 companies does not have any assets whatsoever. This is what I call no income, no asset, NINAS. So how do you deal with that? And companies, it takes its own life. It's a separate legal entity. So there's multiple issues coming at us, not just that. It can be for tax purposes. It can be for money laundering purposes. So you are dealing with this creature, a creature of statute. That's why I say, first you got to have the right law. Once you have the right law in place, you got to put the right people. And for creditors, they just want to get the payment of dividends. And under insolvency, dividends are the proceeds of the sale of those assets. The job of a liquidator, a good liquidator, is to make sure that you sell those assets, you pay off the creditors, and return, if there's any, the surplus to the former directors who are the shareholders. This is where rescue mechanism. My learned friend here talks about judicial manager and the corporate voluntary arrangement. It does not work. When it comes to court winding up matters, parties are at dispute if the company has assets. And in the case of Malaysia, our winding up laws are under the Companies Act 2016. At the petition stage, the court has to ensure that the petitioner nominates a liquidator in the event the court agrees to grant a winding up order. And our finding is the petitioners couldn't be bothered to nominate the approved liquidator. Why? The cost of appointing the liquidator is a lot. So even at that stage, the petition stage, the court, the petitioner, the lawyers who are advising the petitioner must know that you do not simply wind up a company. Lives are at stake. Livelihoods are at stake. When company goes down under, they pay no tax to the government, and the government earns nothing. So that affects the whole ecosystem. At the very beginning, you have the financial stability laws, where banks can go through the credit assessment system to grant loans. And banks, they are earning their profit through those loans. But what happens if there is a default in loans? So this is the whole ecosystem from beginning to the end. We are not just taking this on a compartmentalized approach. No. Most countries, you have a very established entry system. Banks love giving loans. That's why they survive. But when it comes to default, they quickly put in their claims. And they know for a fact that the companies no longer viable, NINAS. And you don't expect liquidators coming down and sweep up everything for the benefit of creditors. This is where the official receiver in Malaysia plays that part as a social balancer, the equalizer. Because most of these companies are small and medium enterprises. You know? So the spectrum of issues converges. So this is where we try to unpack and try to get the low-hanging fruits first. This is where also we want to ensure that there's no preferential treatment over a bigger creditor than a smaller one, as well as a foreign creditor over local creditors. Because essentially you want to make sure that the foundation is right. So to answer your question, I'm sorry, there's no short answer to that. It's not a yes or no. It requires another session, perhaps nearer to Sukhumvit. All right? Thank you.
Thank you very much. So you have mentioned that we need a good law and a good court with a long answer. can I have example of the jurisdiction or any system that you think, okay, maybe not so perfect, but close to a very good models that Asian regions we can follow? It doesn't have to be within Asian, or it could be Malaysian, or it could be
Okay,
anywhere.
a good example would be Luxembourg.
Oh, really?
That's my short answer.
Luxembourg.
Yes.
How, in what aspect?
Okay, they have already established a creditor regime that is very efficient. They have been doing that for the last century. And for your information, MDI is 102 years old. We were established in 1924. But that's how old our system is. We do not move with times. That's why when the cross-border insolvency were passed by Parliament, we have built into that would be our game changer. Everything would have to be digitalized. So taking a leaf from Luxembourg experience, everything is digitalized. So you can do asset tracing. Okay. You know, you follow the breadcrumbs. And not forgetting other laws as well, not just insolvency. You got to have your tax system in place. You got to have your money laundering system in place. This all comes together as a package. So what we do here, from what we can do, is just focusing on insolvency, but we need to harmonize it, not just at the national level, regional and international. So Luxembourg sits just nicely within Europe. But how they do things there, I can tell you, but not here. Thank you.
Yeah, it's about the culture as well, right?
That's right.
And they are a small country.
Yes.
So can we really follow them as, you know, most of us are developing countries with lots of populations and different cultures? Do you think?
Yeah, because legally they inherited the civil system, the continental system. Whereas in Asia, you are a hodgepodge of many systems. There are some civil, there are some common law, there are some hybrid. So that's the challenge, even at ASEAN region, you know. But we have the ASEAN platform. We can talk, we can discuss in the ASEAN spirit because we have the same objective. So the devil are in the details, as always. But, you know, as Confucius said, a journey of 1,000 miles starts with a single step. So I believe today is our first step towards that same journey, same direction. Together with that can-do spirit, you know, when there is a will, there's a way. Thank you.
I believe so and hope so. So we can use them as the guideline and we kind of adapt what we can take, right? So I would like to ask Professor Mohamad Daud that what are the key challenges in reducing delays and improving consistency in the commercial dispute resolution? Let's get into the practical approach.
Well, that is a tough question. But basically, I think, of course, in ensuring that the dispute should be settled without delay, because if you are looking into disputes, I think there are many challenges to be faced. I think basically, if a delay dispute will cause numerous challenges. Basically, okay, the parties will be having unhappiness and trying to. So, okay, you know, of course, creditors will be running up to you. Of course, the court will have to decide on this. So, I think basically it is important for parties to look into how to resolve the dispute in a speedy manner. When a speedy manner, meaning that I think try to work out. I think don't go to the court. The court is the last resort. So it's important for us, for I think lawyers to seek. I think initially, I think we are in Brunei. We are recommending parties for mediation. Mediation is one of the basically called assisted mediation. But if not, then we can go to the Brunei Arbitration Center, or we have an arbitration that can be conducted not only in Brunei, but it can be conducted in Singapore or any other forum that is agreed by parties. I think the main problem that we are facing is if I think the parties should be encouraged. I think in Brunei the court encourage mediation to be considered in the first instance. Let parties work out their differences and let parties to do that. But in the event that I think court system mediation fail, and then it can encourage the arbitration. I think arbitration to look into a possible resolution of that problem by way of arbitration. I think that would encourage parties to come to us. Because as I said, the challenges of having a protracted dispute, I think it is bad for the parties. Of course, in the end of the day, the court will come to the rescue to resolve that. But I think that is not. I think the court may have to decide one way or the other. So sometimes I think it is good for parties to come to an amicable settlement, either by way of mediation or by way of arbitration to resolve the matters. Yeah.
Thank you very much for your perspective. And now, may I ask from your perspective as well, like how do you think we can solve, such challenges in reducing delays and the consistency of the commercial court dispute in your perspective? You have anything in addition?
Well, I think for commercial matters, and I think also maybe part of what this topic had in mind, the issue of more and more specialization, right? So in Malaysia, there are many different types of specialization for courts already, whether you talk about industrial cases or maritime or specific courts with the specialty. So I think somebody did mention that judges need to be good judges, but also there are some of this that other things that come in, right? Which is how for whether it's arbitration or the court system, and you have the technical disputes. What happens is you need to bring your expert witness, and if it's about a certain construction thing or engineering thing or whatever, then you have the experts saying what it is. What some people say, what they're chosen to say or paid for to say, but of course they're experts and they need to do it properly, right? They need to give the evidence properly, and compared with arbitration, where you can have a tribunal with experts, not only those who are legally qualified, but so within the tribunal as well, you have people who have that expertise. So of course, with a court system, you have that as well, right, built in. And of course, the issues there, I suppose there are some operational issues about resources, right? Resources and all of that. And if there are enough cases, then yes, it'll be worth doing. And I think that's what we're seeing more and more of in the region, including Singapore and other places.
Okay, she reminds us already that we have 5 minutes left, so I briefly ask maybe Mr. Syahril of how can court balance creditor protection with the need to facilitate corporate recovery and business continuity in terms of balance?
Okay, to keep it short, 3 things. Number 1, judicial trust. Number 2, institutional integrity. And number 3, regional cooperation. Thank you.
How about you?
I share the views. I think it's important for the court to play a good role in trying to resolve the dispute. of course, in the end of the day, I think the cooperation is required. I think in order to have maybe a regional cooperation is important for us to resolve, because basically investor confidence in Asia will then have to be try to be resolved in the best possible way by cooperation.
Thank you very much. We are concluded for this session. So I would like to thank you, every panelist, for this fruitful discussion. Thank you very much.
Thank you very much once again for both the moderator and the panelists. And again, may I invite Mr. 𝗍cie𝗍𝗲𝗍, Director of the International Strategy Institute, to provide the token of the appreciation to the panelists.